Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only and does not constitute legal, financial, or psychological professional advice. Family law is a complex and highly localized field where regulations can vary significantly from one state to another. Every domestic situation involves unique variables that require personalized professional attention. We are not attorneys, financial planners, or licensed therapists. You should always conduct your own due diligence and consult with a qualified professional in your specific jurisdiction before making any decisions that could affect your legal standing, financial health, or personal well-being. Every single minute in the United States, two couples walk into a courtroom or a mediator's office and decide to end their marriage. That is roughly 2,400 divorces every single day. But while the statistics are cold and clinical, the reality behind them has birthed a massive, multi-million-dollar digital ecosystem that many are now calling Divorce University Online. You have likely seen the clips. You have heard the heated debates on top-tier podcasts where hosts and guests dissect the wreckage of high-profile splits, arguing over prenuptial agreements, alimony, and the psychological warfare of the modern courtroom. There is a reason these discussions are garnering tens of millions of views. We are currently witnessing a cultural shift where the most private failures of the American household are being transformed into a public curriculum. People are no longer just going to lawyers. They are going to YouTube, Spotify, and private online forums to get their degree in how to survive the most expensive and emotionally draining experience of their lives. The question we have to ask is why? Why has the American public become so obsessed with the granular, often brutal details of marital dissolution? The answer lies in the staggering complexity of a system that most people do not understand until they are already trapped inside it. This video series is a deep dive masterclass into that very system. Over the next 10 parts, we are going to deconstruct the syllabus of Divorce University Online. We will look at the historical trends that led us to this point, the case studies of those who navigated the system successfully, and the potential outcomes for those who go in unprepared. Today, we are opening the doors to this unofficial institution to solve one primary problem: the information gap that leaves thousands of Americans financially and emotionally devastated every year. To understand Divorce University, we first have to look at the rise of the expert podcast era. 10 years ago, if you were going through a divorce, your sources of information were limited to a dusty self-help book or a high-priced consultation with an attorney who billed you by the 6-minute increment. Today, the landscape is unrecognizable. Shows like the Divorce Survival Guide or Divorce Under 40 have created a space where the business of divorce is treated with the same strategic intensity as a Silicon Valley startup. These podcasts act as the lecture halls for our modern age. They bring on forensic accountants to explain how to track hidden assets, child psychologists to discuss the nuances of burdensome custody arrangements, and veteran litigators to warn about the common pitfalls of the discovery process. Historical trends show us that the stigma surrounding divorce has eroded, but in its place, a new fear has emerged: the fear of being taken to the cleaners. This fear is the primary driver of the content we see trending today. When a high-profile athlete or a Hollywood star goes through a public split, the Divorce University Online community doesn't just gossip about the drama. They analyze the filing. They look at the choice of law clauses. They discuss the jurisdictional advantages of filing in California versus New York. This level of technical engagement was once reserved for legal scholars, but now it is the standard for anyone with an internet connection and a vested interest in protecting their future. Let's look at a specific case study that highlights why this digital education has become so vital. Consider the concept of no-fault divorce, which is a staple topic in these online discussions. Historically, you had to prove grounds for divorce, such as adultery or cruelty. Today, in the vast majority of U.S. states, you simply need to cite irreconcilable differences. While this was intended to simplify the process, the podcasts and online forums of Divorce University point out a different reality. Without the need to prove fault, the battleground has shifted entirely to the financial and parental arenas. The lectures found online today focus heavily on the equitable distribution versus community property models. For the average viewer, understanding the difference between these two can mean a difference of hundreds of thousands of dollars in a final settlement. The online discussion often centers on the hidden costs of the process. Beyond the legal fees, which can easily spiral into the mid-six figures for contested cases, there is the psychological tuition. This is a recurring theme in the masterclass of online discourse. Hosts often discuss the sunk cost fallacy in relationships, the idea that people stay in a failing situation because they have already invested so much time and effort. Divorce University Online teaches its students to view their marriage as a legal contract that is being dissolved, urging them to separate their emotional trauma from their strategic objectives. This is a cold, hard transition that many find difficult to make without the constant reinforcement of the digital community. Furthermore, we have to address the silver divorce phenomenon, a topic that is currently dominating the airwaves. Data from the National Center for Family and Marriage Research indicates that the divorce rate for adults over the age of 50 has roughly doubled since the 1990s. For those over 65, it has tripled. This demographic represents the senior class of Divorce University. Their discussions are not about who gets the primary residence. They are about the complex division of 401ks, pension plans, and Social Security benefits. The podcasts catering to this group are deep dives into the Qualified Domestic Relations Order, or QDRO. This is a technical legal instrument that allows for the tax-free transfer of retirement funds. 20 years ago, the average person had never heard of a QDRO. Today, thanks to the democratization of information, it is a standard part of the vocabulary for anyone following these discussions. The promise of this deep dive is to give you the context that these viral discussions often miss. While a 30-second clip on social media might give you a hot take on alimony, the reality is far more nuanced. We are going to explore how the digital paper trail has changed the game. In the modern era, Divorce University teaches that your campus is your smartphone. Every text message, every Venmo transaction, and every social media post is potential evidence. We will look at historical trends where digital discovery has completely flipped the script on high-stakes cases. We are also going to examine the role of alternative dispute resolution, or ADR. This is the honors program of Divorce University. It is for those who want to bypass the traditional courtroom drama and settle their affairs through mediation or collaborative law. The discussions online regarding ADR are fascinating because they highlight a growing movement of people who want to disrupt the legal industry. They argue that the traditional adversarial system is designed to maximize billable hours rather than find a fair resolution. By studying these discussions, we can see a potential outcome where the future of divorce is less about winning in front of a judge and more about structured, expert-led negotiation. As we move through this 10-part series, we will leave no stone unturned. We will talk about the divorce industrial complex, the rise of litigation funding, and the impact of artificial intelligence on legal research. This is not just a video about people breaking up. It is a study of how Americans are navigating one of the most significant legal and social challenges of the 21st century. The digital age has turned us all into students of a subject we never hoped to take. Welcome to part 1 of your masterclass on the Divorce University Online. We have a lot of ground to cover, and the syllabus is packed. Let us begin by looking at the specific catalysts that turn a private disagreement into a public legal marathon. To understand how a private disagreement escalates into a public legal marathon, we must first examine the pre-filing curriculum of Divorce University Online. In the year 2026, the first catalyst is almost always digital. We are no longer living in an era where a spouse discovers an affair through a stray receipt or a lipstick stain. Instead, the initiation of the legal process is preceded by what experts on top-tier American podcasts call the digital reconnaissance phase. Historically, the primary catalyst for divorce was a specific event, but in 2026, the catalyst is often the realization that a spouse has been building a secret digital dossier for months, if not years. Imagine a scenario involving Marcus and Chloe, a high-earning couple living in the tech hub of Seattle. Marcus is a lead developer at a major AI firm, and Chloe is a successful interior designer. Their marriage has been strained, but Marcus believes they are working through it in counseling. However, Chloe has been enrolled in an online divorce strategy course for the last 90 days. Following the step-by-step instructions provided by these digital professors, she has already installed a covert tracking software on their shared home network. She isn't looking for infidelity. She is looking for the movement of assets. In the 2026 financial landscape, where Marcus has been diversifying his bonuses into fractionalized real estate on the blockchain and various liquid staking protocols, the paper trail is invisible to a traditional lawyer, but glaringly obvious to someone trained by Divorce University. The second major catalyst we see in current historical trends is the narrative first strike. This is a concept heavily discussed in the manosphere and femsector podcasts that make up the ideological wings of this online institution. The theory is simple. Whoever defines the story first wins the social and often the legal battle. Step by step, these online resources teach individuals how to curate their social media presence months before a filing. They suggest posting photos that emphasize a specific role, perhaps the primary caregiver or the fiscally responsible partner, to create a digital record that can be presented in court as evidence of character. This shift from private reality to public performance is one of the most significant potential outcomes of the Divorce University influence. It turns every family vacation and every birthday party into a strategic asset for future litigation. A massive factor in 2026 is the role of artificial intelligence in discovery. On podcasts like The Modern Split or The Asset Guard, hosts are now detailing how AI-driven software can scan 10 years of a couple's digital life in seconds. This has led to a catalyst known as the metadata disclosure. Imagine if an AI tool could analyze every text message you ever sent to your spouse and determine the exact moment the economic partnership began to fail. In many U.S. jurisdictions, the date of separation is critical for determining which assets are considered marital and which are separate. Divorce University Online provides tutorials on how to trigger this AI analysis early to lock in a separation date that is financially advantageous. This is a level of technical warfare that was unimaginable a decade ago, and it is driving the cost and length of divorces to record highs. Let us look at a case study from early 2026 involving a high-profile silver divorce in Florida. The couple had been married for 35 years, with assets totaling over $15 million. The husband, a retired executive, assumed the process would be a standard equitable distribution. However, the wife had been listening to a specialized podcast focused on forensic lifestyle analysis. She learned how to use AI tools to cross-reference their credit card spending against their GPS data from their connected vehicles. She was able to prove that the husband had been using marital funds to maintain a second residence for several years. The potential outcome was not just a 50-50 split, but a massive unequal distribution based on the dissipation of marital assets. This case serves as a primary lecture in Divorce University. The truth is no longer what you say, it is what the data proves. The psychological catalyst is equally potent. We are seeing a historical trend where the divorce coach is replacing the traditional therapist. These coaches, often found through online forums, do not focus on reconciliation. Their syllabus is centered on emotional decoupling for strategic advantage. They teach students how to remain perfectly calm during a heated argument so that the other spouse's reaction can be recorded and used as evidence of an unstable environment. This is a cold-blooded approach to domestic life that treats the home as a courtroom. By the time a private disagreement reaches the level of a legal filing, one party has often been emotionally weaponized by months of online coaching, making any hope of a low-conflict mediation nearly impossible. Another critical point is the valuation of the invisible in the 2026 economy. As we discuss in these online masterclasses, the most contested assets are often not the house or the car, but things like brand equity and data sovereignty. For example, if a couple runs a successful YouTube channel or a monetized social media presence, who owns the likeness of the children involved? Who owns the historical data of the followers? These are the new frontiers of American divorce law. Online discussions are currently obsessing over social media prenups and digital custody of online personas. The catalyst for many public legal marathons is the sudden realization that a spouse has changed the passwords to the family business accounts, effectively deplatforming their partner and cutting off their primary source of income before a single legal document has been served. The financial first strike also involves the strategic use of debt. Historical trends in 2026 show an increase in defensive borrowing. Students of Divorce University are sometimes advised to take out significant loans or lines of credit against marital assets right before a filing. The logic presented is that it creates a debt shield that makes the total estate look less attractive for distribution, or it provides an immediate war chest of liquid cash to pay for top-tier legal representation. While this is a high-risk strategy that can lead to disastrous potential outcomes if a judge views it as bad faith, it is a topic of constant debate in the online forums. Furthermore, we must address the jurisdictional gambit. With the rise of remote work and digital nomadism in 2026, many American couples find themselves with residences in multiple states. Divorce University Online provides detailed state rankings based on how favorable their laws are for certain outcomes. A spouse might suddenly move to a community property state like Nevada, or a no-alimony jurisdiction to establish residency before filing. This creates a race to the courthouse that turns a private family matter into a multi-state legal jurisdictional battle. The step-by-step guides on how to establish intent for residency, such as changing a driver's license, registering to vote, and opening a local bank account, are among the most downloaded resources in the digital divorce ecosystem. As these catalysts converge, private disagreement is effectively dead. It has been replaced by a systematized dissolution. The couple is no longer two people who fell out of love. They are two litigants who have been trained by competing online ideologies to view the other as an obstacle to their future financial and personal survival. This sets the stage for the most expensive part of the process, the formal filing and the temporary orders phase. But what happens when the first legal papers are actually served? Most people think the battle begins in the courtroom, but the real war is won or lost in the first 72 hours after the server knocks on the door. In the next part of this masterclass, we are going to dive into the shock and awe phase of the Divorce University curriculum. We will examine the specific day one maneuvers that can determine the next 3 years of your life, from the immediate asset freeze to the ex parte custody grab. If you think you know what happens when a divorce starts, you aren't prepared for the 2026 reality of the blueprint. The blueprint for the first 72 hours of a high-stakes American divorce is often described in these online circles as the window of maximum vulnerability. In the year 2026, the serving of process has evolved far beyond the classic image of a stranger handing over a manila envelope. Digital service is now a standard historical trend in many U.S. jurisdictions, meaning that legal notice can arrive via an encrypted link to your primary email, or even a notification through a court-approved social media platform. The moment that link is clicked, the clock starts ticking on what Divorce University Online calls the shock and awe phase. This is the period where the tactical advantages built up during the digital reconnaissance phase are deployed with precision. One of the most critical elements discussed in deep dive podcasts is the implementation of the Automatic Temporary Restraining Order, or ATRO. In many states, including California and New York, these orders go into effect automatically the moment a divorce is filed and served. These are not restraining orders in the sense of physical protection, though those are often filed simultaneously. ATROs are financial handcuffs. They are designed to preserve the status quo of the marital estate. Step by step, they prohibit both parties from transferring, encumbering, concealing, or disposing of any real or personal property without the written consent of the other party or a court order. While this sounds like a fair way to protect both sides, in the 2026 digital economy, it can be weaponized to create an immediate liquidity crisis. Imagine a case study involving a business owner named James in Austin, Texas. James runs a medium-sized logistics firm that relies heavily on revolving lines of credit to manage payroll and fuel costs. The moment James is served with divorce papers, the ATROs take effect. His spouse, who has been studying the Divorce University curriculum, immediately notifies the banks where their joint accounts are held, providing a copy of the filed petition and the standing orders. Because James's business accounts were technically commingled with some marital funds to secure a loan 2 years prior, the bank enters a state of high caution. James suddenly finds his ability to move large sums of capital restricted. His personal credit cards, which were linked to a shared home equity line of credit, are frozen. In a matter of hours, James has gone from a successful CEO to a man who cannot pay his office rent. This is a potential outcome that these online courses warn about: the use of legal standing orders to achieve financial strangulation before the first court date is even set. The next tactical maneuver often highlighted in these discussions is the ex parte order. In the legal world, ex parte means that one party is speaking to the judge without the other party being present. This is reserved for emergencies, but Divorce University Online has popularized the concept of the tactical emergency. The step-by-step strategy often involves filing for an emergency order for exclusive possession of the marital residence or temporary sole custody, based on allegations of imminent harm or the risk of child abduction. Consider a scenario involving Sarah and David in a suburb of Chicago. Sarah has decided to leave the marriage and wants to ensure David cannot re-enter the home to remove any property or intimidate her during the process. She files an ex parte motion alleging that David has a history of erratic behavior and has recently made threats to move their children to another state where his parents live. In the 2026 court system, which is overwhelmed and often relies on digital filings, a judge might sign a temporary order based solely on Sarah's sworn affidavit to maintain safety. When David returns from work, he finds the smart locks on his house have been recoded, his access to the home security system has been revoked, and a police officer is standing in his driveway to serve him with an order that bars him from the premises. He is effectively homeless and separated from his children within 72 hours of the process beginning. Historical trends show that once an ex parte order is in place, the person who was removed faces a massive uphill battle to overturn the status quo, as courts are notoriously slow to change an arrangement that is currently working to keep the peace. These podcasts also emphasize the digital lockdown. Students are instructed to immediately change every password to every non-marital account, but more importantly, to revoke shared access to digital vaults and cloud storage. In 2026, our lives are stored in the cloud. If you share an Apple or Google family plan, your spouse potentially has access to your real-time location, your browsing history, and every photo you take. The first 72 hours are a race to decouple these digital identities. However, there is a massive risk here that the online forums debate fiercely: the risk of spoliation of evidence. If you delete a folder of documents or a history of text messages during this window, an expert forensic analyst can easily discover the deletion. In court, this creates a negative inference, meaning the judge can assume that whatever you deleted was deeply damaging to your case. Divorce University Online doesn't just teach you to hide things. The more advanced modules teach you how to preserve your own data, while legally restricting the other side's access to it. Data from recent years suggests a sharp increase in the use of litigation funding during this initial phase. Because the first 72 hours can result in a freeze of joint assets, the party with less access to liquid cash is often left defenseless. This has given rise to companies that provide high-interest loans specifically for divorce litigation, secured against the eventual settlement. Discussions on podcasts like the Divorce War Chest focus on how to secure this funding within the first 48 hours to hire a high-powered legal team that can move to vacate the ATROs or the ex parte orders. This turns the divorce into a battle of financial endurance from the very start. Step by step, the curriculum also addresses the psychological war of the first 3 days. The advice is almost universal. Do not engage. Every text message sent in a moment of anger, every voicemail left in a state of shock, and every social media post made to seek sympathy is curated as Exhibit A. In 2026, AI sentiment analysis tools are used by law firms to categorize thousands of communications to paint a picture of a spouse as unstable, abusive, or neglectful. The goal of the serving party is often to provoke a reaction that can be documented. The counter-strategy taught online is the gray rock method, becoming as boring and unresponsive as a gray rock. You provide only the most basic, factual information required and nothing more. The potential outcomes of these first 72 hours are profound. By day 4, the lines of the battlefield are drawn. One party may have the house, the children, and the liquid cash, while the other is in a hotel room, struggling to access their own company's payroll accounts. This initial imbalance is often what forces a settlement months later, as the party on the defensive simply runs out of resources to continue the fight. This is why the online community calls it the blueprint. It is about winning the war before the first actual battle in front of a judge ever takes place. But what happens when the dust of the initial serve settles, and both parties realize this isn't going to be a quick process? That is when we enter the longest and most grueling part of the curriculum, the Discovery Deep Dive. Most people think they can keep their secrets hidden, but in the next part we are going to explore how the 2026 version of Discovery uses your own smart appliances, your wearable tech, and even your car's black box to tell a story you never wanted anyone to hear. If you think your deleted search history is gone, you are about to learn the hard way that in Divorce University, there is no such thing as a clean slate. We are going to look at the specific tools and techniques that uncover the truth, from the contents of your hidden crypto wallets to the exact timestamps of every location you visited over the last 3 years. The paper trail is dead, but the data trail is forever. In the modern legal landscape of 2026, the discovery process has undergone a radical transformation that the Divorce University online community refers to as the digital colonoscopy. Historically, discovery involved a tedious exchange of paper documents, bank statements, and tax returns delivered in heavy cardboard boxes. Today, the process is instantaneous, invasive, and almost impossible to evade. If you are going through a high-stakes dissolution in the United States right now, you must understand that your life is no longer private. It is a collection of searchable data points. Let us look at the first pillar of modern discovery, the Internet of Things, or IoT. Imagine a case study involving a husband named Michael and Charlotte, North Carolina. Michael has claimed in his financial affidavits that he is living a modest lifestyle and has seen a significant downturn in his consulting business. However, his spouse's legal team has issued a subpoena for the data logs of his high-end smart home system. Step by step, they analyze the metadata from his smart refrigerator, his climate control system, and his automated security gates. The data reveals that Michael is hosting lavish dinner parties 3 nights a week, with the refrigerator logging the purchase of premium imported goods, and the security system recording the entry of dozens of luxury vehicles. Historical trends show that judges are increasingly receptive to this type of circumstantial digital evidence because, unlike a human witness, the sensor data from a smart home cannot be coached and it does not forget. The second pillar is the biometric trail provided by wearable technology. In 2026, nearly 60% of the American workforce wears some form of health tracking device. These devices are the silent witnesses of our most intimate moments. Consider an imagine-if scenario where a spouse claims they were at home sleeping during a time when they were allegedly engaging in an extramarital affair. In a modern deposition, a forensic expert can present heart rate data and GPS coordinates from a wearable device that show the individual was actually in a state of high physical exertion at a specific location 5 miles from their home. This level of granular detail can dismantle a person's credibility in minutes. Potential outcomes of such a revelation often include the immediate collapse of a settlement position, as the lying party loses all leverage before the court. Step by step, the discovery process now begins with a demand for a forensic image of all electronic devices. This is not just a copy of your files. It is a bit-for-bit duplication of your entire hard drive, including the unallocated space where deleted files reside. When you delete a photo or a text message, the operating system simply marks that space as available for new data. Until it is overwritten, that information is still there. Divorce University online forums are filled with horror stories of individuals who thought they were safe because they used disappearing message apps or factory reset their phones. Forensic tools used in 2026 can often reconstruct these fragments, creating a timeline of communication that contradicts the official narrative. We must also address the evolution of financial discovery. The era of hiding cash under a mattress is over, replaced by the complexities of the decentralized financial web. If you have been moving marital assets into cryptocurrency, you are participating in a historical trend known as digital asset dissipation. While many believe that certain coins offer total anonymity, the reality in 2026 is that forensic accountants use sophisticated blockchain analysis software to track the flow of funds from a joint bank account into an exchange and eventually into a cold wallet. They look for the digital breadcrumbs, the small verification transfers, the installation of wallet apps, and the seed phrases often hidden in plain sight within digital notes or email drafts. Imagine a case study where a wife, Chloe, discovered her husband had shifted $200,000 into an obscure DeFi protocol. By subpoenaing his internet service provider logs, her team identified the timestamps of his connections to specific decentralized exchanges. They then matched those timestamps with the public ledger of the blockchain. Even without his private keys, they were able to prove the existence of the assets, leading to a court-ordered offset where Chloe received a larger share of the physical real estate to compensate for the hidden digital wealth. This is the power of the data trail. It creates a mathematical certainty that is very difficult to argue against in a courtroom. The automotive black box is another critical frontier. Modern vehicles in 2026 record everything from your average speed to the weight of the person in the passenger seat. In a contested custody battle, this data can be used to prove that a parent is driving recklessly with children in the car, or that they are frequenting locations that are inconsistent with a healthy parenting environment. Step by step, a legal team will request the EDR or event data recorder logs. If a father claims he is always home by 8 p.m. to tuck his kids in, but his Tesla logs show the vehicle arriving home at 2 a.m. 4 nights a week, the credibility gap becomes an unbridgeable chasm. Furthermore, we are seeing the rise of AI-powered social media scrapers. These tools don't just look at your public profile. They analyze the public profiles of your friends, family, and colleagues to find photos or mentions of you that you didn't authorize. They can use facial recognition to find you in the background of someone else's vacation photo in Cabo, when you told the court you were too sick to attend a mandatory mediation session. This interconnectedness means that your privacy is only as secure as the least private person in your social circle. The cost of this deep dive discovery is staggering. Historical trends indicate that a full digital forensic audit can add tens of thousands of dollars to a legal bill. However, for many, the potential outcomes justify the expense. In Divorce University Online, this is known as the war of attrition. The goal is often to find that one piece of data, the smoking gun, that forces the other side to capitulate to avoid a public trial. Whether it is a deleted email to a secret business partner or a heart rate spike at a specific GPS coordinate, the data trail is the new gold standard of truth in the American legal system. What people often fail to realize is that this process is reciprocal. If you are digging into your spouse's data, they are almost certainly digging into yours. This creates a state of mutual assured destruction where both parties' secrets are laid bare for their attorneys, the judge, and eventually, the public record. Many participants in these online discussions emphasize the importance of a digital cleanse before filing. But in 2026, a pre-filing cleanse can be interpreted as intentional destruction of evidence, leading to severe sanctions. The discovery phase is the longest, most painful part of the journey, because it strips away the personas we build for ourselves. It forces us to confront the reality of our actions, documented in cold, hard metadata. But once the data is collected and the secrets are out, the focus shifts to the most public and potentially damaging part of the process, the narrative war. In the next part of our masterclass, we are going to explore how these digital discoveries are weaponized in the court of public opinion. We will look at the rise of the influencer divorce and how social media is used to destroy reputations before a judge ever hears a word of testimony. We will examine the specific tactics used to turn a person's own data against them to create a narrative of unfitness or financial misconduct that can follow them for the rest of their career. If you think discovery is bad, wait until you see what happens when that data goes viral. We are entering the world of character assassination in the digital age, and the rules of engagement have never been more dangerous. The courtroom used to be the final arena for marital disputes, but in 2026, the traditional legal system is far too slow for the modern litigant. By the time a judge actually reviews the forensic data we discussed, the trial has already taken place in the court of public opinion. Welcome to the narrative war, a phase of the Divorce University curriculum that focuses entirely on digital character assassination. The strategy discussed on top-tier podcasts is no longer just about winning the legal case. It is about destroying the opposing party's social and professional equity so completely that they are forced to surrender. We are seeing a historical trend where the most devastating blows are not delivered through legal motions, but through weaponized algorithms and highly coordinated social media campaigns. To understand how this operates in the current year, we must look at the phenomenon of the influencer divorce. You do not need millions of followers to be subjected to this. In the modern economy, everyone is a micro-influencer within their own network. Whether that is a neighborhood Facebook group, a professional LinkedIn circle, or a local church community. The tactics taught in online forums outline a step-by-step process for poisoning the well. The first step is often the cryptic primer. This involves posting vague but emotionally charged content about surviving narcissism, escaping financial abuse, or protecting one's peace. The goal is not to make a direct accusation, which could trigger a defamation lawsuit, but to plant a seed of doubt in the minds of mutual friends and colleagues. Imagine a case study involving a couple named Kevin and Jessica, who run a highly successful boutique real estate firm in Denver. They built their entire brand on the image of being a dynamic, trustworthy husband and wife team. When their marriage begins to collapse, Jessica, having studied the aggressive tactics detailed on the Surviving the Split podcast, realizes that whoever controls the narrative controls the business. Before the first temporary orders are even filed, the data mined during the discovery phase is strategically leaked. Jessica does not post the data herself. Instead, historical trends show the rise of the proxy attack. Anonymous burner accounts or highly sympathetic friends begin feeding out-of-context text messages and cherry-picked financial statements to local community pages and industry message boards. The potential outcomes of this strategy are catastrophic for the targeted spouse. Within days, Kevin finds his professional reputation entirely dismantled. Clients begin pulling their listings, citing rumors of financial instability and unethical behavior. When Kevin attempts to defend himself, he falls into a psychological trap widely discussed in these online masterclasses. The defensive posture makes him look guilty. If he remains silent, the allegations become the accepted truth. This is the exact dilemma the narrative war is designed to create. It is a paralyzing state of crisis management that distracts the targeted spouse from the actual legal proceedings, draining their emotional energy and their financial resources as they scramble to hire crisis PR firms alongside their litigation team. We must also examine the role of the podcast tour. In 2026, One of the most effective ways to launder a smear campaign is to rebrand it as advocacy. The spouse executing the narrative strike will book appearances on lifestyle or mental health podcasts under the guise of raising awareness for toxic relationships. Step by step, they will recount highly sanitized versions of their marital issues, using the therapeutic language popularized by Divorce University to frame themselves as the absolute victim and their ex-partner as a clinical abuser. Because podcast hosts rarely cross-examine their guests or fact-check personal anecdotes, this one-sided narrative is broadcasted to tens of thousands of listeners. The algorithm, which heavily favors high-conflict, emotionally triggering content, pushes these clips across multiple platforms. The personal disagreement is fully monetized by the creator economy, turning the destruction of a family into a viral spectacle. You might assume that the legal system has mechanisms to stop this, but the online curriculum knows exactly how to bypass them. Gag orders and non-disparagement clauses are standard requests in family court, but in the 2026 digital landscape, they are remarkably difficult to enforce. If an anonymous account operating through a virtual private network in another country is posting damaging metadata about your financial history, proving that your spouse orchestrated the leak is a nearly impossible technical challenge. By the time a cyberforensics team can trace the IP address, the damage is already done. The targeted individual has lost their job, their business partnerships have dissolved, and their social standing has been eradicated. Consider another scenario involving a corporate executive named Robert in Atlanta. Robert is not a public figure. He is a supply chain manager for a large logistics company. During his divorce, his ex-wife utilizes a targeted professional disruption campaign. She compiles public records of his corporate bonus structures, mixes them with isolated moments of marital frustration captured on home security cameras, and creates a narrative that Robert is hiding wealth while starving his family. She does not post this on casual social media. She utilizes targeted ads on professional networking sites, specifically geofenced to Robert's corporate headquarters and the zip codes of his executive board. The potential outcome is swift. The Human Resources Department, wanting to avoid any association with a messy public scandal, quietly asks Robert to take an indefinite leave of absence. His income stream is severed right when he needs it most to fund his legal defense. This strategy relies on the weaponization of the mob. Divorce University discussions frequently analyze how to incite parasocial outrage. Once a narrative gains traction, strangers on the internet will take up the cause. They will review bomb the targeted spouse's business with 1-star ratings. They will flood the employer's phone lines with demands for termination. They will dox the spouse's new address or the identities of their new social circle. The psychological toll of this digital vigilantism is profound. Litigants are experiencing symptoms similar to combat trauma, caused by the relentless, invisible pressure of being hunted by an algorithmic mob that does not know them but hates the avatar created by their ex-partner. The most chilling aspect of the narrative war is that it is often entirely legal. The line between sharing one's personal truth and executing a calculated campaign of professional sabotage is incredibly thin, and the First Amendment provides a massive shield for the aggressor. As long as the aggressor relies on opinions, carefully worded implications, and proxy leaks, they can devastate their target without ever crossing the threshold of actionable defamation. The Divorce University curriculum teaches its students how to walk this tightrope perfectly, ensuring maximum damage with minimum legal liability. This phase of the process strips away the final layers of humanity in the dissolution of the marriage. It proves that in 2026, you are not just fighting your spouse, you are fighting their followers, the algorithm, and a culture that views personal tragedy as entertainment. But as devastating as it is to lose your reputation and your livelihood to a viral smear campaign, it is only a precursor to the most high-stakes battle of all. The narrative war destroys the present, but the next phase is about completely controlling the future. If you think the weaponization of social media is terrifying, you are completely unprepared for how these exact same psychological tactics are deployed inside the home. In the next part of our masterclass, we are going to expose the darkest chapter of the syllabus. We will break down the modern mechanics of parental alienation, showing exactly how one parent systematically rewrites a child's memory and turns them into the ultimate weapon against the other. The term parental alienation is often thrown around in online forums as a buzzword, but in the curriculum of Divorce University Online, it is treated as the tactical deployment of psychological influence. In the year 2026, we are seeing a historical trend where the child is no longer just a bystander in a domestic dispute. They have become the ultimate piece of leverage. This is the darkest chapter of the digital divorce era because it involves the systematic rewriting of a child's reality. Podcasts that cater to high-conflict demographics often mask these strategies under the guise of protective parenting or trauma-informed care, but the underlying mechanics are designed to achieve one specific goal: the total erasure of the other parent from the child's emotional landscape. To understand how this functions in 2026, we must look at the step-by-step mechanics of the slow drip. This is not a sudden explosion of hostility. It is a meticulously paced campaign of psychological suggestion. The alienating parent begins by using therapeutic language to pathologize the other parent in front of the child. They don't say your father is a bad person. Instead, they say, "I'm so worried about your father's emotional regulation," or "I hope your mother can find the help she needs to be a stable parent again." By using the language of concern, the alienating parent bypasses the child's natural defenses. They are not attacking, they are rescuing. This creates a us versus them dynamic that is a hallmark of divorce university strategy. Imagine a case study involving a father named Marcus in Columbus, Ohio. Marcus was a present, active father who coached his son's little league team for 5 years. When the divorce filing hit in early 2026, his ex-wife, who had been consuming content on the Alienation Mastery forums, began the process of the memory rewrite. Step by step, she began to reinterpret past events for their 10-year-old son. When Marcus had raised his voice once during a stressful move 3 years prior, she reframed it as a pattern of explosive rage. She began to ask the son leading questions like, "Do you remember how scared we were when Daddy got like that?" Over months of repetition, the child's own authentic memory of a loving father was replaced by a manufactured narrative of fear. Potential outcomes of this specific tactic include the child eventually refusing to attend scheduled visitation, which then provides the alienating parent with a legal pretext to file for sole custody based on the child's preference. The second pillar of modern alienation is digital gatekeeping and surveillance. In 2026, every child has a digital footprint, often through a smartphone, a tablet, or a gaming console. The alienating parent utilizes these devices as a tether. They might install tracking software or frequently call and text the child during the other parent's time, ostensibly to check in, but functionally to disrupt the bonding process. On podcasts like The Parenting Pivot, hosts discuss how to use parenting apps, tools designed to reduce conflict, as weapons of administrative exhaustion. They might flood the app with hundreds of mundane questions or accusations, making it impossible for the targeted parent to focus on the child. Consider an imagine-if scenario where a mother named Chloe in San Diego is the targeted parent. Her ex-husband has provided their teenage daughter with a high-end VR headset and a premium smartphone with an unlimited data plan, both of which are controlled by him. When the daughter is at Chloe's house, the father uses these devices to create a constant digital presence. He rewards the daughter with digital currency for video games every time she shares a detail about Chloe's personal life or who Chloe is seeing. This turns the child into a domestic spy. If Chloe tries to limit the screen time to foster a real-world connection, the father frames it to the daughter as Chloe being controlling and jealous of her happiness. Historical trends in 2026 show that this digital triangulation is one of the most difficult forms of alienation for the court system to identify and stop, as it happens in the privacy of a child's digital world. Furthermore, we must address the weaponization of the child's agency. In many U.S. jurisdictions, as a child gets older, a judge may give more weight to their stated preference regarding custody. Divorce University online forums provide detailed instructions on how to coach a child for a meeting with a guardian ad litem or a court-appointed psychologist. This is known as the scripting phase. The child is taught to use specific buzzwords that trigger a legal response. Words like unsafe, uncomfortable, or neglected. The alienating parent doesn't tell the child to lie. They simply validate the child's manufactured feelings so intensely that the child believes the lie is their own truth. Data from family court studies in 2026 indicates a rise in the use of forensic psychological evaluations to combat this. These are deep-dive investigations where a professional observes the family dynamic over weeks. However, the alienating parent is often coached by online consultants on how to perform during these evaluations. They are taught to appear as the quintessential cooperative parent, while subtly dropping hints that the child's rejection of the other parent is entirely organic. This creates a potential outcome where the targeted parent is labeled as the problem because they appear angry, frustrated, and reactive, reactions that are a natural response to being systematically erased from their child's life. Another high-stakes tactic is financial alienation. This is especially prevalent in the 2026 economy, where the cost of living and extracurricular activities for children has skyrocketed. The alienating parent, if they have more liquid capital, will often position themselves as the yes parent. They will pay for the elite sports camps, the international school trips, and the luxury electronics, all while telling the child that the other parent is choosing not to contribute because they don't value the child's future. This creates a transactional relationship where the child's loyalty is effectively purchased, and the less wealthy parent is viewed as a burden or a disappointment. The psychological cost to the child in these scenarios is immense. Historical trends in adult children of high-conflict divorce show that those who were subjected to alienation tactics often suffer from complex PTSD, identity confusion, and an inability to form stable adult relationships. They eventually realize they were used as a pawn in a game they didn't understand, leading to a profound sense of betrayal. Yet, the Divorce University online ecosystem continues to thrive because the immediate legal and emotional payoff for the alienating parent is so high. As the child becomes more entrenched in the alienating parent's camp, the legal battle takes on a new level of ferocity. We are no longer talking about assets or schedules. We are talking about the complete severance of a biological and emotional bond. This is where the Divorce University curriculum moves into its final, most aggressive phase. The litigation has reached a fever pitch, and both parties are preparing for the ultimate showdown: the trial. Most people assume that a trial is about presenting the truth to a judge who will then make a fair decision. But in the world of high-conflict American divorce, the trial is a carefully choreographed performance where the goal is not truth, but the total disqualification of the opponent. In the next part of our masterclass, we are going to pull back the curtain on the courtroom theater. We will examine how lawyers use the data, the narratives, and the alienated children we have discussed to create a final crushing blow. We will look at the specific 2026 techniques for cross-examining expert witnesses and how a single minute of testimony can change the trajectory of a family for the next 20 years. If you think you've seen the worst of the system, you haven't seen what happens when the gavel finally comes down. Welcome to the courtroom theater. When the gavel finally comes down to open a contested divorce trial in the year 2026, the American public largely still believes they are stepping into a sanctuary of truth. Television and movies have conditioned us to expect a climactic moment where justice prevails and the righteous party is vindicated. But if you have been paying attention to the syllabus of Divorce University Online, you know that the modern family court is not a laboratory for discovering the truth. It is an arena for procedural warfare. The trial is the ultimate performance, and the litigants are the actors, heavily scripted by their attorneys and the endless hours of podcast strategy they have consumed over the preceding months. Historical trends from the past decade show a massive shift in how these trials are conducted. We are no longer relying primarily on witness testimony detailing who was a better spouse. The modern trial is a battle of expert witnesses, data analysts, and forensic accountants. Step by step, the strategy taught in online forums focuses on disqualifying the opposing side's experts before they can even present their core findings to the judge. In the legal community, this is known as a Daubert challenge, but in the digital divorce ecosystem, it is simply referred to as the expert takedown. Let us explore an imagine-if scenario to illustrate this 2026 reality. Imagine a couple named Thomas and Rachel in Phoenix, Arizona. Thomas is a successful entrepreneur who runs a lucrative chain of automated car washes, and Rachel is a marketing executive. During the trial, Rachel's legal team brings in a highly paid forensic business valuator to testify that Thomas's business is worth $10 million. Thus exponentially increasing the marital estate and her potential payout. 10 years ago, Thomas's lawyer would have simply brought in a different expert to argue a lower number, leaving the judge to pick a number in the middle. Today, the strategy is vastly more aggressive. Thomas has been studying the advanced financial modules of online divorce communities. His legal team uses AI-driven legal research software to instantly cross-reference every single testimony Rachel's expert has ever given in the state of Arizona. Within seconds, the software finds a case from 3 years prior where this exact same expert used a completely different valuation methodology to assess a very similar automated business, resulting in a significantly lower valuation. On the stand, Thomas's attorney traps the expert. They do not argue the math of the current car wash business. They argue the integrity and consistency of the expert. Step by step, they force the expert to admit they changed their methodology specifically to inflate the numbers for Rachel's case. The expert's credibility is dismantled in under 5 minutes. The judge dismisses the $10 million valuation entirely, and Rachel's entire financial strategy collapses in real time. This is not about the absolute truth of the business value. It is about the weaponization of historical data to win a procedural victory. Potential outcomes like this are exactly why the preparation phase is so grueling and heavily emphasized on popular legal podcasts. This brings us to the most brutal aspect of the trial, the cross-examination of the spouses themselves. Divorce University podcasts dedicate hundreds of hours to a concept known as the deposition trap. Litigants are taught that the opposing counsel is not asking questions to gather new information. They already have the answers. They are asking questions to create a contradiction under oath. Every single word you say on the witness stand is being actively compared to the terabytes of digital discovery we discussed in the earlier phases of this masterclass. Consider a case study from a recent high-conflict trial in Chicago. The husband took the stand and testified under oath that he had never consumed alcohol around his children during his weekend visitations, presenting himself as the ultimate model of responsibility. The opposing counsel did not yell or dramatically present a hidden photograph. Instead, they calmly introduced the metadata from the husband's own smart refrigerator and his food delivery apps from the past 6 months. The data showed that on 12 separate occasions, premium liquor was delivered to the house on a Friday night, and the smart refrigerator registered the dispensing of custom ice specific to cocktail glasses multiple times between the hours of 8 and 11 in the evening, precisely when the children were sleeping in the home. The husband was caught in a definitive data-backed lie. In the 2026 courtroom, a lie like this does not just damage your credibility regarding the alcohol. It invokes a powerful legal concept that can destroy your entire standing. If the judge believes you lied about the liquor, they are legally permitted to assume you are lying about your income, your hidden assets, and your parenting capabilities. Your entire case is infected by a single data point that you forgot existed. The online forums warn their students relentlessly about this exact scenario. The masterclass rule is simple. Never testify against your own digital footprint, because the data will always win. Furthermore, we must examine the strategy of attrition by trial. Contested trials are astronomically expensive. By the time a couple reaches the courtroom in a major metropolitan area, they have often spent hundreds of thousands of dollars. The online syllabus teaches a highly controversial tactic for the spouse with the deeper pockets or better litigation funding: prolonging the agony. This involves filing endless evidentiary objections, introducing thousands of pages of complex financial exhibits that take days to review, and calling an excessive number of character witnesses. The goal is to literally bleed the opposing spouse dry, forcing them to run out of capital mid-trial. When a litigant can no longer afford their attorney's daily trial fee, they are faced with a terrifying potential outcome: proceeding pro se, which means representing themselves against a seasoned, heavily armed trial lawyer. When you listen to the podcasts analyzing these specific trial strategies, the language used is completely indistinguishable from military doctrine. They talk about supply lines, which translates to cash flow. They talk about psychological operations, which translates to intimidating witnesses in the hallway. The courtroom theater is fundamentally designed to break the human spirit. The judge sits high above the fray, observing the carnage, tasked with applying cold legal statutes to the burning wreckage of a family. They do not have the time or the emotional bandwidth to care about the intricacies of your broken heart. They care about statutory guidelines, precedent, and the strict rules of evidence. After days or sometimes weeks of this grueling performance, the trial concludes. The lawyers pack up their briefcases, the digital presentation screens in the courtroom are powered down, and the litigants are sent home to wait. The wait for the final judgment can take months. During this agonizing period, the psychological toll reaches its absolute peak. You have surrendered your entire life, your deepest secrets, and your financial future to a stranger in a black robe who has only seen the worst, most heavily litigated version of who you are. Eventually, the ruling arrives in the mail or via a digital portal. The court issues a binding decree that dictates exactly how you will live, how much money you will have, and when you are allowed to see your own children. For many, they look at this final judgment and assume this piece of paper is the finish line. They believe the war is finally over, the bleeding has stopped, and they can begin to rebuild their lives in peace. But the most seasoned professors of Divorce University Online know a dark and terrifying truth about the American legal system. A court order is only as strong as your ability to enforce it. And in the modern era, enforcement is a completely different battlefield. What happens when your ex-spouse simply refuses to pay the court-ordered alimony? What happens when they pack up the children and vanish into a different jurisdiction, hiding behind decentralized cryptocurrency to avoid asset seizure? In the next part of this masterclass, we are going to dive into the post-judgment nightmare. We will explore the shadow economy of hiding assets after the trial, the rise of interstate custody evasion, and exactly how the digital tools we have discussed are used to hunt down a spouse who decides that the judge's ruling simply does not apply to them. You survived the trial, but the real hunt is just beginning. In the year 2026, the final decree of divorce is often misunderstood as the finish line, but for many participants in high-conflict domestic litigation, it is merely the opening bell for a second, more exhausting round of conflict. Many Americans assume that once a judge signs the order, bank accounts will automatically split, and support checks will start arriving like clockwork. Historical trends, however, suggest that nearly 40% of court-ordered settlements in high-stakes cases face significant non-compliance within the first 24 months. This is what the Divorce University online community calls the paper shield. You have the legal right to the money or the time with your children, but the actual possession of those rights requires a whole new set of tactical skills. The hunt is no longer about proving who is right. It is about finding what has been hidden. One of the most complex pillars of this post-judgment phase is the pursuit of hidden assets, specifically in the realm of decentralized finance. Let us look at a case study involving a man named Ethan in Seattle. Ethan was ordered by a Washington state court to pay his ex-wife, Maya, a lump sum of $800,000 as part of their property division. Ethan, having spent months in deep dive webinars on private asset management, utilized a strategy often discussed in the darker corners of the internet. Step by step, Ethan moved his liquid capital through a series of privacy-focused blockchain protocols and non-custodial wallets. He utilized mixing services to obscuring the origin of the funds, and then shifted the value into fractionalized digital real estate in jurisdictions that do not recognize U.S. civil judgments. On paper, Ethan appears insolvent. His primary bank accounts are nearly empty, and his paycheck is being garnished to the maximum legal limit, yet he continues to live a lifestyle that suggests vast wealth. Maya is now forced to hire a new kind of professional, a digital bounty hunter specializing in blockchain forensics. In 2026, the primary tool for this hunt is open source intelligence, or OSINT. While Ethan believes his assets are invisible, his digital behavior provides a constant stream of metadata. If Ethan posts a photo of a high-end meal in a city where he has no reported business interests, or if his wearable technology logs a heart rate and GPS elevation that matches a luxury ski resort in the Swiss Alps, OSINT experts can use this data to petition the court for a finding of contempt. Historical trends show that judges are becoming increasingly willing to accept this type of circumstantial digital evidence. When Maya's team presents the court with a timeline of Ethan's digital footprints that contradicts his claims of poverty, the potential outcome is a civil arrest warrant or the seizure of his remaining domestic physical assets. We must also examine the jurisdictional jump, a tactic frequently debated on podcasts like The Global Parent. Imagine an if scenario where a mother named Isabella in Miami is granted primary physical custody of her two children. Her ex-husband, Alejandro, feels the system is biased against him and decides to implement the relocation gambit. Under the guise of a standard weekend visit, Alejandro crosses state lines or even international borders into a jurisdiction that has a history of slow cooperation with the Hague Convention. In 2026, the hunt for a missing parent is no longer just about police bulletins. It involves the real-time monitoring of geofence data and the tracking of IP addresses used to access educational apps or streaming services used by the children. The step-by-step process of recovery involves obtaining a writ of assistance, which allows law enforcement to physically reclaim the children. However, the legal and logistical costs of this recovery can reach into the hundreds of thousands of dollars, making it a war of financial endurance. The alimony strike is another common historical trend we see in the 2026 economy. This is often called strategic underemployment. We see case studies where a high-earning executive suddenly resigns from their position to become a consultant with zero reported income, while their luxury expenses are being paid by a new domestic partner or a shell corporation. Divorce University Online provides detailed tutorials on the legal concept of imputed income. This is a step-by-step process where your attorney proves to the court that the ex-spouse is capable of earning a specific amount based on their education and vocational history, regardless of what their current tax return claims. In 2026, courts are using AI-driven labor market data to determine what a person should be earning, effectively stripping away the excuse of voluntary unemployment to avoid support obligations. The role of the private investigator has also evolved. They no longer simply sit in a car with binoculars. They utilize drone surveillance, AI-powered license plate readers, and signal interceptors to document the true life of the non-compliant spouse. Imagine a scenario where a husband claims he cannot afford child support, yet a drone captures footage of him overseeing the construction of a luxury vacation home. This evidence, while powerful, must be gathered according to strict state-level privacy laws to be admissible in court. The online discussions frequently debate the legality of these surveillance techniques, as a single procedural mistake can lead to the evidence being suppressed and the investigator being charged with harassment. Furthermore, we are seeing a move toward what experts call the automated settlement. This is a potential outcome where courts may eventually require large divorce settlements to be placed in third-party escrow accounts or managed by smart contracts that automatically release funds based on specific triggers, such as the first day of the month or a child reaching the age of majority. While this technology is available in 2026, its adoption is slow, leaving the burden of enforcement on the individual. This creates a cycle of zombie litigation, where the parties return to court every 6 months for contempt hearings, modifications of support, and arguments over unpaid expenses. The case never truly ends, it just changes form. The psychological curriculum of Divorce University Online often overlooks the long-term mental health implications of being in a state of perpetual pursuit. When your financial survival depends on successfully hunting your former partner, you are never truly free from the marriage. You are bound to them by a chain of legal motions and forensic audits. This leads to a state of hypervigilance where every social media post or news item regarding the ex-spouse is analyzed for hidden meaning. It is a toxic bond that prevents healing and keeps the emotional wounds of the divorce fresh for years. The hunt is a war of attrition that consumes what is left of the family's resources and the parent's sanity. But as we move toward the final sections of this masterclass, we have to look beyond the tracking data and the bank statements. We have to look at the collateral damage that doesn't show up in a legal filing. The digital trail, the narrative wars, and the courtroom theater have a profound long-term impact on the one group of people who never signed up for the university, the children. In the next part, we are going to explore the generational echo. We will look at the long-term data on how the divorce university generation is growing up, and how the tactical warfare of their parents is being baked into their own psychological DNA. We will examine the rise of identity fragmentation in children who were used as data points, and how they are navigating their own adult relationships in an era where love is increasingly viewed through the lens of a legal contract. If you think the hunt for assets is hard, you haven't seen the true cost of the fallout. The generational echo of Divorce University Online is not a distant psychological theory. It is an observable, data-backed phenomenon in the year 2026. We are currently witnessing the first wave of children who were raised as data points in the high-conflict digital wars of the early 2020s reaching adulthood. These individuals are the literal alumni of their parents' litigation. For them, the fallout is not a set of legal documents or a bank balance. It is an ingrained systemic shift in how they perceive human connection, trust, and the very definition of a family unit. Historical trends suggest that this generation is moving toward a highly contractualized view of romance, where love is secondary to risk management. To understand this, we must examine the concept of the digital inheritance. In 2026, a child's trauma is no longer private. Imagine a case study involving a 19-year-old college student named Ava in Boston. When Ava was 12, her parents went through a brutal 3-year dissolution that was heavily featured in the narrative war phase we discussed earlier. Her mother, a lifestyle influencer, posted weekly updates about the psychological toll of the divorce, using Ava's emotional reactions as content to garner sympathy and algorithmic reach. Today, when Ava applies for an internship or meets a new social circle, her parents' most toxic moments are just a search query away. She is not just Ava. She is the girl from those viral videos about parental alienation. This potential outcome is a form of identity fragmentation. Ava struggles to separate her authentic self from the curated victim persona her mother created for her in the digital court of public opinion. Step by step, we are seeing this play out in the rise of relationship risk management among young adults. In 2026, dating apps have evolved to include features that feel more like a background check than a romantic introduction. Historical trends indicate that children from high-conflict divorce university backgrounds are the primary users of these tools. They are seeking what podcasts call the pre-dated audit. Imagine if, before a third date, You exchanged a digital vault of information that included not just credit scores, but a litigation history of your immediate family. These young adults are looking for a litigation propensity score. If your parents were involved in a decade-long legal marathon, the data suggests you may be viewed as a higher risk for a high-conflict future. This is the professionalization of dating, a direct result of seeing the home transformed into a courtroom during their formative years. Furthermore, we must address the psychological DNA of the surveillance generation. Children who were subjected to the biometric trail and the digital gatekeeping we explored in Part 6 often grow up with a distorted sense of privacy. For a child like Leo in Seattle, whose every GPS coordinate was tracked by his father to prove his mother was violating a geofenced custody order, the concept of a safe space is non-existent. In 2026, as Leo enters his first serious relationship, he finds himself pathologically checking his partner's location. He isn't trying to be controlling. He is simply operating on the only survival software he was ever given. Potential outcomes for these individuals often include a high rate of relationship anxiety and a total inability to function without constant digital verification of their partner's movements. They have been trained to believe that trust is a liability and that only data is true. The financial fallout for this generation is equally profound. We are seeing a historical trend where the children of high-asset divorces are opting for what are known as lifestyle agreements before they even consider a marriage license. In the 2026 economy, these are not just prenups. They are granular contracts that dictate everything from the frequency of social media posts to the specific AI tools that will be used for future child rearing. These young adults have seen their parents' wealth evaporated by legal fees and forensic accountants. Their goal is to pre-solve every potential conflict through a series of if-then statements. Love, in their eyes, is a legal liability that must be mitigated through rigorous documentation. Let us look at a case study of the Gray Rock generation. These are children who survived high-conflict homes by becoming emotionally unresponsive to avoid being used as weapons by their parents. In 2026, mental health professionals are reporting a surge in young adults who exhibit a profound emotional flattening. They are highly functional, successful in the gig economy, and technologically savvy, but they are terrified of deep emotional intimacy. To them, a deep emotional bond is a vulnerability that an ex-partner can eventually use to destroy you. They are the ultimate students of Divorce University, having learned that the best way to win the game is to refuse to play it with any real skin in the game. Another critical factor is the institutionalization of the American home. For children of 2026, the home was often a place where parents spoke in the language of legal motions. They didn't have arguments. They had disputes that required mediation. They didn't have chores. They had responsibilities outlined in a court-ordered parenting plan. This has led to a generation that views the family not as a biological or emotional sanctuary, but as a mini-corporation. We are seeing a rise in young people who, when faced with a roommate dispute or a workplace conflict, immediately jump to the language of harassment, evidence, and documentation. They have been conditioned to believe that every human interaction is a potential exhibit for a future trial. Data from 2026 also shows a significant shift in the concept of data sovereignty for minors. We are seeing a rise in lawsuits filed by young adults against their own parents for the unauthorized use of their likeness and personal data during divorce proceedings. This is the counterstrike of the alumni. They are suing for the digital cleanup of their childhoods, demanding that their parents pay for the removal of toxic content from the internet. This is a potential outcome that the Divorce University curriculum never warned parents about. That the child who was once a pawn will eventually become a litigant, using the very legal tools they were forced to observe against the people who raised them. The generational echo is a feedback loop. As these children become parents, they are implementing a new style of parenting that is almost entirely focused on legal and digital protection. They are the generation of the social media prenup and the digital trust. They are attempting to build a world where the messiness of a 20th century divorce is impossible. But in doing so, they are creating a world where the spontaneity and vulnerability of a 20th century family are also becoming extinct. The curriculum of Divorce University is being passed down, not as a warning, but as a blueprint for survival in a world that they believe is fundamentally adversarial. As we look at the wreckage of the modern family and the tactical landscape of 2026, we have to ask ourselves, is there a way out, or have we fundamentally changed the nature of the American household forever? The hunt for assets, the narrative wars, and the courtroom theater have all led to this point. A generation that views a marriage certificate as a risk assessment and a child as a potential legal liability. But every masterclass must eventually reach its final exam. We have covered the tactics, the technology, and the trauma. Now, we must look at the conclusion of the curriculum. In the final part of this series, we are going to explore the graduation from Divorce University. We will examine the emerging counter-movements that are attempting to dismantle this industrial complex. We will look at the rise of private, AI-governed arbitration, and the radical new models of family law that promise to bypass the courtroom entirely. Is it possible to find peace in a system designed for war? We are going to reveal the final strategy for those who want to survive the university without losing their humanity. This is the end of the syllabus, and the final lesson is the one you least expect. The final lesson of Divorce University Online is not a tactical maneuver or a hidden legal loophole. It is the realization that in the year 2026, the most successful graduates are the ones who refuse to cross the threshold of the courtroom entirely. We are entering the era of the post-litigious dissolution. For years, the American public has been fed a curriculum of conflict, taught by podcasts and forums that the only way to protect one's future is through total administrative and digital annihilation of the former partner. However, historical trends in 2026 show a massive pivot toward the algorithmic arbitrator. This is a system where the messy, biased, and expensive human element of the judiciary is replaced by a cold, objective, and lightning-fast AI protocol. Imagine an if scenario involving a couple named Julian and Sarah in Denver. They are both high-earning professionals with 2 children and a complex portfolio of traditional stocks and staked digital assets. In a 2022 world, their divorce would have taken 3 years and cost $400,000 in legal fees. In 2026, they choose the graduation strategy. Instead of hiring 2 adversarial law firms, they enroll in a decentralized arbitration protocol. Step by step, they grant a specialized AI engine read-only access to their entire financial history, their shared calendars, and their digital communication logs. The AI does not care about Julian's ego or Sarah's resentment. It applies the specific statutes of Colorado law to the raw data. Within 48 hours, the AI generates a proposed settlement that is mathematically fair based on historical trends of local court rulings. It suggests a custody schedule that maximizes the children's stability based on the family's actual movement patterns over the last 5 years. Because the AI is seen as an impartial, data-driven entity, the emotional heat is drained from the process. Julian and Sarah sign the agreement, which is then automatically filed with the court as a stipulated judgment. The potential outcome is a dissolution that is finalized in weeks rather than years, preserving 98% of the marital wealth that would have otherwise been consumed by the divorce industrial complex. This move toward private arbitration is the primary countermovement we are seeing in 2026. Podcasts like the Peace Protocol or the No Court Solution are the new required listening for the elite class of Divorce University. They argue that the traditional family court is a 20th century relic that is fundamentally incapable of handling 21st century complexity. They teach that the ultimate victory is not getting a larger share of the house, but rather achieving an exit velocity that allows both parties to start their new lives without being tethered to a decade of debt and resentment. However, we must look at the step-by-step reality of the exit interview for those who have already been through the war. In 2026, we are seeing the rise of identity rebranding services. These are firms that specialize in cleaning up the digital debris left behind by a narrative war. If you were the target of a viral smear campaign or a proxy attack, these specialists use AI-driven SEO tactics to bury the toxic content and replace it with a professional, neutral persona. They work with graduates of Divorce University to help them transition from being a litigant back to being a civilian. This is a critical historical trend because it recognizes that the damage of a modern divorce is often permanent, unless active measures are taken to reclaim one's digital sovereignty. We also have to address the evolution of the prenuptial agreement in 2026, which has shifted from a defensive document to an operational manual. Modern American couples who have seen the carnage of the previous decade are now entering marriages with what are called dynamic trusts. These are legal structures where marital assets are categorized and managed in real time by smart contracts. If a triggering event occurs, such as a filing for separation, the assets are distributed according to the pre-agreed logic of the contract, effectively bypassing the discovery phase entirely. Case studies show that couples with these digital guardrails experience 70% less conflict during a dissolution, because there is nothing left to fight over. The math was decided when they were still in love. This brings us to the most difficult part of the graduation syllabus: emotional de-escalation. In 2026, top-tier coaches are teaching a technique called the parallel parenting protocol. This is for the high-conflict cases where the bridge has been burned beyond repair. It involves a total cessation of direct communication. Instead, parents interact through an AI intermediary that scrubs their messages for hostile language, filters out irrelevant emotional venting, and presents only the factual information necessary for co-parenting. The potential outcome is a state of cold peace where the children are no longer the conduits for their parents' animosity. Historical trends indicate that children raised in parallel parenting environments show significantly lower rates of the identity fragmentation we discussed in the previous part. The final exam of Divorce University Online is the realization that the system is designed to be a perpetual motion machine of conflict. The lawyers, the forensic experts, the mediators, and the podcast hosts all benefit from the escalation. The final strategy, the one you least expect, is the act of radical forgiveness, not as a moral gesture, but as a financial and psychological imperative. In 2026, forgiveness is viewed through the lens of cost-benefit analysis. By refusing to pursue the last 10% of a settlement or the final hour of a custody schedule, a graduate can save millions of dollars in future litigation and thousands of hours of life force. This is the ultimate hack: the realization that your peace of mind has a higher valuation than any marital asset. As we conclude this deep dive masterclass, we look at the historical data of the last 10 years and see a clear divergence. There are those who stay enrolled in the university forever, living in a state of permanent litigation, and there are those who graduate. The graduates are those who accept that the data trail is permanent, the narrative war is a zero-sum game, and the courtroom theater is a performance they no longer wish to attend. They utilize the 2026 tools, AI arbitration, digital trusts, and identity recovery, to create a clean break. The story of the American household is being rewritten by the very tools that once threatened to destroy it. We are seeing a future where the Divorce University Online might eventually be replaced by the Relationship Resilience Academy. But for now, as you stand at the end of this syllabus, the choice is yours. You have the data, you have the strategies, and you have seen the potential outcomes. The gavel is about to fall on your own story. What will your legacy be when the data trail finally goes quiet? Will you be a warning for the next generation? Or will you be the architect of a new kind of peace? The final chapter of your divorce hasn't been written yet, and in the year 2026, you have more power over that ending than any judge in any courtroom. The masterclass is over, but your new life is just beginning. Every choice you make from this second forward determines whether you are a victim of the system or a master of your own future. The blueprint is in your hands.